Hello, everyone. My name is Michael Palmieri. I'm the Executive Director of Creative Lab Hawaii. On behalf of Georgia Skinner, Chief Officer of the State of Hawaii DBED Creative Industries Division and founder of Creative Lab Hawaii, mahalo for participating in our Zoom webinar tonight. In a moment, I will introduce our presenter, though I first wanted to share with you a little bit about our webinar. Our presentation will last approximately 40 to 45 minutes, which will give us about 10 to 15 minutes for questions from you, our viewers. If you're interested in asking a question, please do so as the discussion unfolds and by clicking on the question section that's located on the bottom center bar of your Zoom platform. We will look to answer as many of the questions as time allows. As a reminder, the series of legal clinics taking place this month are informational purposes only. If you require specific legal advice, we recommend that you consult an attorney. Also, our presenter will make the slides available for all of the individuals who are participating tonight in the live webinar and have RSVP'd via our Zoom platform. So now let me introduce to you our presenter of this panel, Martin Hsia. Martin is a partner at Cades, Schutte, LLP, and his practice includes advising clients about all aspects of U.S. foreign and international intellectual property rights, filing and prosecuting U.S. and international patent and trademark applications and U.S. copyright applications, representing clients working with the firm's litigation practice group in proceedings before the U.S. federal courts, the U.S. trademark trial and appeal board, and the U.S. patent trial and appeal board, as well as filing and prosecuting through an extensive network of foreign correspondents, foreign patent and trademark applications, and prosecuting and defending opposition and cancellation proceedings before the patent and trademark offices of many of the major industrialized countries in the world. Martin has been listed in Best Lawyers in America for 25 years and is also listed in Martindale Hubbell Bar Register of Preeminent Lawyers and Who's Who in American Law. He has given addresses on intellectual property matters to groups as diverse as the American Bar Association Business Law Section, United States Trademark Association, the Chamber of Commerce of Hawaii, the Rotary Club, innovation workshops sponsored by the U.S. Department of Energy, the National Association of Paralegals, a third grade class studying inventions, as well as major colleges and universities and other organizations. Here's Martin.
Thank you very much for that introduction. What we have on the screen is going to be just the opening of the materials that will be sent to you. So do not try to take notes on this. Pay particular attention to what's on the screen. I don't want you to be distracted. We're going to be covering quite a lot of stuff. The first thing I just want to call attention to is Chatham House rule applies. It's stated on the grayed out text at the bottom. Participants are free to use the information received, but neither the identity nor the affiliation of the speaker nor that of any other participant may be revealed. Also, because I am giving this speech and I am an attorney and I do see copyright law, any copying or unauthorized copying or retransmission as stated in the materials here without my express written consent will constitute willful infringement and result in liability of up to $150,000 plus attorney's fees. If you saw my speech last week, you understand why. Anyway, next slide, please. So what I'm going to do is start with a very basic question. Where does trademark law come from? Trademark law is a little different from copyright law. Those of you who saw my speech last week knew that copyright law is almost purely federal. Trademark law is both state and federal, and it's also foreign because unlike copyright, trademarks are country by country. So the first bullet point is the Congress shall have the power to regulate commerce with foreign nations and among the several states. That is the basis for trademark law. Trademarks are marks that are used in trade. And so it's the power of the Congress from Article 1, Section 8, Clause 3 of the U.S. Constitution that gives the power to regulate commerce. The current federal statute that was passed by Congress is the Lanham Act of 1946, as amended by the Trademark Law Revision Act of 1988, which was effective November 16, 1989, plus various other acts, most recently including the Trademark Modernization Act, which was passed December 27, 2020. There are certain other federal statutes which affect trademarks, such as the Olympics Act, the Boy Scouts Act, and the Red Cross Act. Those particular entities have their own trademark laws that are protecting their specific emblems. Then there's also state law. I'm giving this address from Hawaii. So the Hawaii statutes that are applicable are the Hawaii Statute on Trademark Registration, Chapter 482, Hawaii Revised Statutes, the Hawaii Statute in Chapter 480, which is Hawaii's unfair competition law, and then the Hawaii Statute 481A, Chapter 481A, which is the Uniform, Unfair, and Deceptive Trade Practice Act, which has been adopted by a number of states and across the country as well. Similarly, Chapter 480 is modeled after a federal statute, and many states in the country have adopted the same kind of statute. And Chapter 482, the portion relating to trademarks and service marks, is based on the Model Trademark Act, which was created by the International Trademark Association. The trade name portion is unique, though, to Hawaii. And then finally, there's Hawaii common law, which is judge-made law, where judges look at what has happened in prior cases. And although there may not be a statute applicable, those judges will make a determination based on what prior case law. Next slide, please. So what do federal trademark laws protect? I'm dealing with federal trademark laws. The term trademark in the first bullet point, oh, by the way, I've given the slides in text, but you can ignore everything that's not bolded and not underlined, because I gave it to you in text so you'd be able to find it later on if you needed to, and you see the context, but I wanted to make sure that you had the general concepts, and that's why I underlined those important terms. So trademark is any word, name, symbol, or device, or any combination thereof, and that's defined by the statute as to identify and distinguish his or her goods from those manufactured or sold by others, and to indicate the source of the goods. That's what a trademark is. It indicates who's the person who made it or sold it, and is to differentiate. A service mark is to identify and distinguish the services of one person from the services of others, and to indicate the source of the services. So trademarks and service marks are for identifying and distinguishing, and to indicate source. So that's the function of trademarks and service marks. And then this is from a federal statute, and the intent of the chapter of that statute is to regulate commerce within the control of Congress by making actionable the deceptive and misleading use of marks in commerce. So Congress wants to be able to stop you from being deceived and misled by trademarks. And I'll get into more of that later on. And then to also protect persons engaged in interstate commerce against unfair competition, and to prevent fraud and deception. Notice that there's no federal trade name protection. I'll go into trade names later on, but this is only covering trademarks and service marks. Next slide, please. Federal trademark laws also protect against what's called unfair competition under Section 1125, 15 U.S.C. 1125. And basically, the statutory section says any word, term, name, symbol, or device, that's a trademark, or any combination thereof, or any false designation of origin. That would mean saying, for example, that it's potatoes made in California, they call them Idaho potatoes. That's going to be a false designation of origin, or a false or misleading description of fact, or a false or misleading representation of fact. A lot of pain reliever cases come about with that because there are arguments about, hey, that was a misleading description of how your pain reliever works. So that's what's actionable under this unfair competition. And why is it actionable? Because it might be likely to cause confusion as to affiliation, connection, or association, or origin, sponsorship, or approval, or it misrepresents the nature, characteristics, qualities, or geographic origin of goods, services, or commercial activities. So that's federal unfair competition, all under statute 15 U.S.C. 1125. If you violate by causing a likelihood of confusion, or you're misrepresenting something about the goods or services, then you're liable for unfair competition. Next slide, please. There are newer kinds of trademark protection done in the federal laws. Dilution is one of them. Dilution by blurring and dilution by tarnishment. There are two different kinds of dilution. Dilution is basically reducing the uniqueness of a trademark. So the examples in the statute that adopted it were Buick for shoes. That reduces the uniqueness of Buick for a car, or DuPont for aspirin. So that's dilution by blurring, because something that's a unique mark that tends to be recognized even outside the range of goods with which it's normally used, you're reducing that uniqueness. The second thing is dilution by tarnishment. Dilution by tarnishment is where you use this brand name in a manner that does not cause confusion, but you tarnish the reputation because you're giving it some kind of a unsavory kind of connection, such as Tiffany for dog food. So those are two kinds of dilution. And so in actuality, if someone's registering or trying to register a trademark that is not close enough to cause a likelihood of confusion, but is likely to cause dilution, you might be able to stop them from doing that dilution by blurring or dilution by tarnishment. Next slide, please. This is a relatively new one, a new federal law, cyber piracy prevention. If someone has a bad faith intent to profit from you by registering your brand name as a domain name, by using an identical or confusingly similar domain name, then that's cyber squatting. And cyber squatting is something that you can't sue in federal court for. Usually it's more expensive, and that's why people will usually do a domain name cyber squatting, a domain name arbitration case for a cyber squatter. But this is also actionable under federal law. Next slide, please. Now we move from the federal law to the state law. First thing you should know is that the United States is not one country. The United States is not one country. The United States is not one country. It is 50 little countries with a federal government. That is why, for example, you can have marijuana being legal in Colorado, even though it's illegal under federal law, because in Colorado, the Colorado legislature decided to make it legal. And the problem is you cannot use anything that is federal. So that means they cannot use the banking system. So if you want to buy marijuana in Colorado, you cannot use a bank because that's subject to federal regulation. You have to use cash. So anyway, Hawaii has its own trademark laws. Every state has its own trademark laws. Most of them are very similar. Many of them have adopted the same law, the Model Trademark Act, that Hawaii did. So here you'll see a lot of similarity. Trademark is a word, name, symbol, or device, or any combination used to identify and distinguish the source of goods and to indicate the source of the goods. Same thing for service mark, same kind of definition. And then there's a definition of a trade name. A trade name means any name used by a person to identify a business or vocation of the person. A trade name is sometimes called a DBA. That's what it is. Or in other jurisdictions, it's called a fictitious name. It's the name under which you do business. And then the other thing that Hawaii trademark laws give you that you can't really get in federal law is the ability to get an administrative order of abatement against someone who's registered a name of an entity, a Hawaii entity, that is infringing on your name. When you have a corporation that has a name that's equal to the same, that's identical to your trademark, if they're not using that name in public, there's no trademark infringement because there's no one to be confused because it's only being used privately. No one's seeing the name. But Hawaii law does give you the ability to go against that entity and force them to change their name through what's called an administrative order of abatement. Next slide, please. What is not protectable by a trademark? A trademark does not protect against what's called fair use. It's called classic fair use nowadays. Fair use is where a trademark does not take words out of the English language. It only allows you to use a designation and be able to use that designation, the same English words in the English language as you always could. That's called fair use. So, for example, in the KP permanent makeup case, there was something where they called them microcolors, and there were small colors. So microcolors was a fair use case. So California Pizza Kitchen, arguably, if someone was in a pizza, was opening a kitchen or a sort of pizza in California, using the term saying we're a California pizza kitchen would be a classic fair use, as long as you didn't do it in a manner that was a trademark usage, that is to identify and distinguish your goods and services. It wasn't your brand. It's just saying we're a pizza kitchen in California. When I first moved to America, Philadelphia cream cheese. That's cream cheese from Philadelphia. Kentucky fried chicken from Kentucky. So that's classic fair use. Windows for windows that open on your desktop on a computer. Then the other kind of fair use is nominative fair use, and that's a case called New Kids on the Block versus News America publications. Because what happens is, if you cannot refer to the particular product or service without actually using its brand name, then that's called nominative fair use. In that case, what happened was they were taking a poll to see who was the favorite member of the New Kids on the Block. And that test of nominative fair use has basically been adopted throughout the whole country, even though there's no federal legislation on it. And basically, bottom line is, as long as you don't use someone's logo or use more than of their mark than is necessary, you are allowed to refer to them. Deceptive matter is not registrable. Deceptive matter is something like lovey lamb or seat covers that are not made of lamb. They're made of artificial fabric. And whether it's deceptive or not depends on whether someone would find the misstatement to be material to the decision to purchase. So for lovey lamb, if people would usually want to buy actual lamb, so that's why it's deceptive. If, however, you're dealing with something that's not really important to the purchasing decision, then it's not going to be deceptive, it'll be misdescriptive. So something like Mars or a candy bar is geographically misdescriptive, but it's not deceptive. It's not that important that it comes from Mars. And obviously it didn't come from Mars. The next one is primarily geographic, deceptively misdescriptive marks. And that's where Idaho potatoes, not from Idaho, that would not be registrable or protectable because it's deceptive. So the point is you're trying to avoid deception. I know we're in Hawaii, and Hawaii has the best marijuana in the country, but trademarks for marijuana and other goods or services that are unlawful in interstate commerce, you cannot get a federal trademark registration for those. You cannot get a federal registration for coats of arms or other insignia of U.S. or states or municipalities or a foreign nation. You cannot for a misdescriptive geographical indication for wines and spirits. This is because the U.S. joined the World Trade Organization. So champagne can no longer be used for a sparkling wine. Can only be used for a wine that comes from the Champagne region of France. We have this for wines and spirits. We don't have it for a lot of other kinds of goods. There are many other countries in the world, they do have it. If we had it in Hawaii, it would be really good because there's a lot of food here that could benefit a lot from having a geographic indication. We are not, the United States is not a member of the, I think it's the Lisbon Treaty that helps protect geographic indications. Maybe sometime in the future that'll happen, but we don't know now. The name, portrait, or signature of a living individual or deceased present during the life of the widow, except with consent. Those are not registrable. Generic terms, car for cars, apple for apples. So anyway, those are the kinds of things that are not protectable by trademark. Next slide, please. What's protected by a trademark after a market recognition has been achieved? So what happens is people come in and say, I want to register a trademark. And business people always say, I want a brand that's going to describe what I'm doing. The problem is everybody else in the world also has the right to describe what they're doing. When I want to say I'm from Hawaii, well, everybody else in Hawaii has the right to say they're from Hawaii. If, however, you have achieved enough recognition that someone recognizes that not just as, oh, some magazine from Honolulu, but, oh, I recognize that magazine is a single magazine that I've seen before, like Honolulu Magazine. Or foremost is a laudatory term, which normally would not be registrable immediately because it just says I'm the best. But best foods, you recognize that, and so it achieved this second meaning. California's Pizza Kitchen has achieved a second meaning. It has a primary descriptive meaning of kitchen restaurant from California that serves pizza. And when they first opened, they could not get registered for that. Same thing for Microsoft when they first started a word processing program, they called it Word. They filed a federal trademark application, they got refused, they appealed, they lost. Same thing with California Pizza Kitchen. Why? Because Word is, or Windows, excuse me, it's Windows. Windows is directly descriptive of a computer program that operates in Windows on your desktop. But after enough recognition has been achieved, then California Pizza Kitchen and Windows have achieved enough recognition to become registrable and protectable as trademarks. McDonald's, the same thing. A surname is usually not registrable immediately because there are other people with the same surname. But after so many billions of hamburgers sold, McDonald's has achieved a secondary meaning. There are two meanings to the mark. One is somebody named McDonald's opened a restaurant. The other is Golden Arches. It's a single source. Non-distinctive words or trade dress, such as product configurations and packaging, those are not protectable. If, however, it's achieved enough recognition, then it can be protectable. The shape of the Coca-Cola bottle is something that works. And similarly, the pineapple shape for a cookie, that's one I've registered. A color, pink for insulation, that is a federally registered trademark. And that took a lot of work and it went up to the U.S. Supreme Court. Very, very, very recently, I think it was Booking.com. The U.S. Supreme Court said that Booking.com, a domain name containing a generic term, was registrable as a trademark, which was a shock to most of us in trademark law, but that's the U.S. Supreme Court. And it's been said that they are not Supreme Court is not final because it's supreme. It's supreme because it's final. So anyway, next slide, please. What rights are granted by a trademark? The protection against a likelihood of confusion in courts and at the U.S. Patent and Trademark Office. And in the state of Hawaii, it's different. The state of Hawaii, the registrars, I testified against this, but many years ago, the DCCA, Department of Commerce and Consumer Affairs, said we want to amend our statute so our counter clerks do not have to decide whether there's a conflict between names that are being applied for. So they will allow registration of anything as long as it's not substantially identical. If two people have a beef about it, they can go ahead and file a petition to cancel. So that's how we are at the state. So if you have a state registration and somebody else decides to register something that's confusingly similar but not substantially identical, then that will be allowed registration, and your only avenue is going to be to file a petition to cancel. Another right granted by trademarks is to record your federal trademark registration at customs, and if you're lucky, customs will block the infringing imports. So if someone tries to bring in something into the country that's an infringement, customs may block it. If somebody has stolen your domain name and you have a federal trademark registration, you can file a domain name arbitration under the Uniform Domain Name Dispute Resolution Policy. And then also a federal registration gives you the basis for filing foreign trademark applications and recording those foreign trademark registrations with foreign customs offices. And one that's actually practical use for a lot of people is you're able to register with the Amazon brand registry and other websites, e-commerce sites, and be able to say, hey, these people are infringing on my trademark. Remember, a federal trademark registration is good throughout the United States. A state registration is only good in Hawaii. And also a US registration gives you no rights whatsoever outside the United States. That's different from copyright. Copyright gives you international protection automatically under what's called the Berne Convention. Trademarks is country by country. Next slide, please. Who owns the trademark rights? This is a very sticky and difficult issue. I'll try to explain it in a manner that you'll understand, but it's something that even sophisticated trademark attorneys on the mainland don't understand. When you don't have an issued federal registration, no one has a registration. The first to adopt and use a trademark in any particular geographic territory owns the trademark in that territory. The reason why that's so important in Hawaii is because we're surrounded by water. So there's no neighboring state line. On the mainland, the reason why people don't worry about it so much is because there's always a neighboring state, except for Alaska. And therefore, it's easy to be in interstate commerce. And that's why when someone's adopting and using a trademark in a geographic territory, it may be a multi-state territory relatively easily. The next bullet point is if there's a federal registration, the federal register owns the trademark rights throughout the whole country, except where someone may have established actual usage in a pre-application geographic market. I tell all my clients, if you possibly can, you file a federal trademark application. Why? Because if you start on day one and you create a great business in Hawaii, and day 30, someone else does not know about you, adopts the same name and the same mark in California, and they expand throughout California, when you are ready to expand to California, even if you may have a federal registration, you can't kick the people out of California because they had their actual usage before your application was filed. Federal trademark application gives you retroactive trademark rights, retroactive to filing date. That is critically important for a client that I'm working on right now, where there's a nationwide company that's doing a mark that's very similar to ours. And thank goodness we filed a federal trademark application. So we can go after them on federal ground as soon as our registration issues. The person who actually controls the quality of the goods and services is the one that actually owns the trademark rights. So if the Patent and Trademark Office doesn't care, though, between the parent and the subsidiary. Typically what happens is either a foreign company will create a U.S. subsidiary, or the foreign company will itself own the trademark in the country, or it may decide that it's going to have the U.S. subsidiary own the trademark. So there are all these issues you have to deal with. It becomes important because when you're dealing with a trademark dispute, you want to be able to file a lawsuit against people in a particular court. And we were very lucky because someone had their foreign subsidiary own the U.S. trademark registration. So we were able to sue them. It was the foreign company that owned the registration. So we were able to sue them in Hawaii because a foreign entity can be sued in any case, any court in the country, whereas a U.S. entity can only be sued where it actually is incorporated or certain other places, and it's different between patents and other kinds of laws. And then the person who conceded the trademark, such as the ad agency, does not own the trademark rights. Next slide, please. What can be trademarks? We already talked about word, name, symbol, or device, recognized product shapes, the Coca-Cola design, packaging designs. For example, the fleur-de-lis pattern on the Louis Vuitton purses is recognized pattern applied to the product. Sounds. In this audience, the MGM lion roar or the NBC three tones, those are trademarks. Scents, I can't send a scent over the internet. A disparaging mark can be trademark. That was the case relating to the mark, the slants, disparaging name for Asians. That went to the U.S. Supreme Court. And that portion of the statute which said you can't register disparaging marks was ruled to be unconstitutional. Immoral or scandalous marks are also ruled not to be, they can be trademarks. So that's the U.S. Supreme Court as well. So there are a lot of FU marks that were applied for directly after that. And then a generic term, domain name, I described that as the booking.com case. Next slide, please. How do you transfer trademark rights? You should have a written assignment or written transfer that says, I hereby transfer my trademark rights to this, together with all goodwill and together with all rights to sue past infringement. If you don't recite together with all rights to sue for past infringement, those rights may not pass. For federally registered trademarks, you should record the assignment at the U.S. Patent and Trademark Office Assignment Division. For Hawaii registered trade names, trademarks, and service marks, you should use the DCCA's printed form and file it at the DCCA. The licensee of a trademark does not have the right to grant sublicenses. The licensee does not have the right to grant sublicense unless the license says you can. And that's a case relating to the Glenn Miller ban, the Ninth Circuit, as a matter of fact. Next slide, please. How long does a trademark last, and how do you lose a trademark? A trademark lasts forever. As long as you are using the mark and there's no abandonment, and the mark has not become a generic term like nylon or aspirin, then the trademark can last forever. Smith Brothers is a cough drop. That trademark has lasted over 100 years. Under federal law, non-use for 3 years is presumed to be abandonment, and that's true of most other countries' laws as well. There are new procedures that are coming into effect on December 27, 2021 for expungement and cancellation of federal registrations. Under Hawaii law, there's non-use for 2 years presumed to be abandonment for trademarks and service marks, and 365 days of non-use is presumed to be abandonment for trade names. A really important one is that failure to control the goods, the quality of the goods and services provided by a licensee, such as by providing annual samples, is naked licensing. Naked licensing, and results in loss of all trademark rights. So I know this is a G-rated talk, but I did have to talk about naked licensing. If a trademark becomes a generic term, all trademark rights are lost. Aspirin, nylon, and escalator. Do not try to get your own federal trademark registration. Let me repeat that. Do not try to get your own federal trademark registration. There are several main reasons for that. One is that you're going to screw it up. I've never seen anyone do it right. And it's even more important now. When I was first preparing for the speech about 2 weeks ago, I was doing the slides, I was going to say, I've given you enough information, you can prepare your own. Then the U.S. Patent and Trademark Office put on a webinar showing their new examining procedures for declarations of continuing use and what they're going to be doing in their new audit procedures. They're going to be auditing, I think, 2,500 renewal applications every year. So now what happens is I changed my advice. Do not file it yourself because a couple of reasons. Also, I've seen some experience from other clients. If you file your own federal trademark application, you're very likely to screw it up and get a refusal. You get 6 months to respond to the refusal. You'll probably overlook the deadline. Even if you don't and you apply, you may not be able to overcome the refusal. If you are able to overcome the refusal, if you file an intent to use basis every 6 months, you got to file an extension request until you can file your statement of use and get your notice of allowance and get your registration issued. Well, the problem is that you'll probably overlook one of those 6 month deadlines. Every day, I have to send reminders to my clients, hey, your deadline's coming up in a month. And many times they don't remember about it until that very day. Then it becomes abandoned. Then, once your registration is issued, you've got to file renewal requests every 10th year and also between the 5th and the 6th anniversary. Many people forget about that. So if you do your own trademark application, you're not going to have a docketing system or a calendaring system that keeps track of all these deadlines. And I'm not even talking about the deadlines for foreign countries. So you need to be aware of that. So that's why don't file the application by yourself. If you do, number one, you're going to screw it up and then you're not going to be able to go into court with it. Number two, it's probably going to end up being canceled because you missed some deadline. A trademark registration can also be canceled on any ground for which registration could have been refused while it's less than 5 years old. After it's 5 years old, there are only certain grounds you can challenge it on. Next slide. What's trademark infringement? Someone does reproduction, counterfeit, copy, or colorable imitation of a registered mark that's likely to cause confusion or to cause mistake or to deceive. That's what trademark infringement is. Likely to cause confusion or to deceive. And you can see that's all throughout this whole section. And if you do something like that, you're liable in a civil action for all the damages and remedies provided in 482-33. Next slide, please. So just remember, trademarks protect you against likelihood of confusion. Can a court order a stop to trademark infringement? Yes, it can. The court can issue an injunction, that is a court order, saying that you shall stop violating the rights of the registrant. On December 27, 2020, the sentence in the middle of this was added. A plaintiff seeking any such injunction shall be entitled to a rebuttable presumption of irreparable harm. So what that means is that you're basically going to be able to ask for the judge for an injunction, and you don't have to prove that your harm can be repaired by the payment of money. Prior to December 27, 2020, if you want to get a court to order someone to stop infringing, you also had to prove that your harm cannot be repaired by payment of money. Trademarks is business. In business, any damage can probably be repaired by the payment of money. This really strengthens the ability to pursue and get an injunction from the court. This rebuttable presumption of irreparable harm. This rebuttable presumption of irreparable harm does not apply to copyrights, does not apply for patents. So those are still relatively difficult in some senses. And so what happens is the owner can enjoin the manufacture, use, display, or sale of any counterfeits or imitations of the mark. So that's what the court can do. Next slide, please. Can a court order payment of money and attorney's fees? Yes, the court can. Subject to the principles of equity, the court can give profits and costs, and in assessing profits, you only have to prove the defendant's growth sales. You only have to say they sold $1 million worth of it. That's all you got to prove. The defendant must say, well, my profits were actually a lot less, and the defendant has to prove all the elements of cost for deduction. And if it's something where the amount that's recovery based on profits is inadequate or excessive, you can ask for up to 3 times the amount, which the court can do in its discretion. In exceptional cases, the court may award reasonable attorney's fees to the prevailing party. So usually you don't get attorney's fees in a run-of-the-mill trademark infringement case. However, in a recent Supreme Court case, Romag versus Fossil, willfulness is not required to recover profits. So if someone is infringing on your trademark, you don't have to prove they're willful in order to be able to recover your profits. Then you are also entitled to recover your damages. Now, if you're dealing with, and this is another reason for you to get a trademark registered federally, is that you can get treble damages if it was committed, if the wrongful acts were committed knowingly or in bad faith. This is on the state level. That's the bottom paragraph here. So at the state level, you can actually ask for treble damages, not just the damages, but 3 times the damages. Next slide, please. It's kind of a lot of fun to do a seizure for counterfeiting. I've gone to Aloha Stadium with 10, 15 teams of sheriffs and marshals, and we always have to have 2 representatives from the client with each team. You have an ex parte order, that is a secret order from the court. The other side has not been served with it. It says, you shall walk up to these booths that are selling counterfeit, serve them with this order, and seize the infringing merchandise. It's a lot of fun to do that. You end up with a truck full of counterfeit merchandise. So that's pain. It's very expensive. It's a pain to get through, but it is a procedure that's available. And it's something where it's quite effective, because if you don't do that, they all say, well, I bought this stuff from a guy named Mr. Kim, and I never saw him before, and I won't see him since. I actually put some of these guys under a deposition with lights on them and videotape them, and they still said, oh, I just got this stuff from Mr. Kim. I don't know who he is, whatever. So they're hardened criminals who are doing counterfeiting, and counterfeit goods often travel in the same channels as drugs. So I've gotten more than one phone call from the police saying, we busted this guy for drugs, and he's also got the counterfeit stuff. So anyway, a counterfeit is an exact duplicate, which is meant to be something you can sell as a substitute for the product. And don't do counterfeiting. Next slide, please. The reason you don't do counterfeiting is because subsection B, second bullet point, says, if it's counterfeit, the court shall, unless the court finds extenuating circumstances, enter judgment for 3 times the profits or damages. And also they can award prejudgment interest. Next slide, please. And if you use counterfeit marks, in the middle of the slide, you see the court can award statutory damages for not less than 1,000 or more than 200,000. A $200,000 per limit per counterfeit mark per type of goods or services. $200,000 is a very substantial liability. And if the court finds that the use of the counterfeit mark was willful, not more than $2 million per counterfeit mark per type of goods or services offered for sale or distributed, as the court considers just. Why such high amounts? Counterfeit products are not just handbags and watches. There have been counterfeit medications, counterfeit helicopter parts. People die because of counterfeits. That's why. And then there's statutory damages for a domain name for cyber squatting between $1,000 and $100,000 as the court considers just. Probably this would be done by a jury if there's a jury trial because of a case related to copyright where the same language is used where the court considers just. And someone argued that, hey, it says the court considers just, so that means I'm entitled to a jury trial on it. The court had awarded a couple of $100 per unit, so they won at the Supreme Court. And so when they got the jury trial, they were awarded $2,000 per unit. So they won the battle, lost the war. Next slide, please. If you do a wrongful seizure, you may be liable for the other side's attorney's fees. I had that happen where the Italian companies, designer manufacturers, in-house counsel told me, go ahead and do the seizure. We did all the seizure and everything. And then we find out that they were genuine. And at that point, they took over because there is a potential liability to conduct a wrongful seizure. So if you're going to do a counterfeiting seizure, you got to be sure you're right. Usually it's not a problem. Next slide, please. Why should you register the trademark rights? You can read this if you want later on. But basically, the most important one is the first big underlying portion. Constructive use of the mark, conferring a right of priority, nationwide in effect, on or in connection with the goods or services specified in the registration. That's what I told you before. You get nationwide priority. That allows you to push out anyone who established the usage after your application filing date. And then the next big portion that I've underlined said, registered mark has been used in 5 consecutive years for subsequent to the date of registration is still in use in commerce, shall be incontestable. I have actually held off on filing lawsuits when my registration is 4.5 years old until it became 5 years old and then filed the lawsuit because the value of becoming incontestable is almost impossible to defend against the registration. Federal registrations get much stronger when they're 5 years old. You cannot cancel them because you have earlier rights. You cannot cancel them if they're a descriptive term, if you file this incontestability affidavit. So they're much more powerful. And so that's why it's very worthwhile to get a federal registration. State registrations, they don't get stronger as they get older. Also, if you're ever going to sell your business or you want to get invested in your business, how are you going to prove you own the trademark rights outside the state of Hawaii? You need a federal trademark registration. Next slide, please. When? You should register your trademark rights as soon as possible. I believe that you guys were sent my booklet, and in my booklet at the beginning, it has a timeline of when you should apply for various things. As soon as possible after a limited liability entity has been created. That's when you file your federal trademark application or your state trademark application. The reason you want the entity to apply is because the owner of a trademark is liable for damages caused by the goods or services bearing the trademark. That's really, really important. You put your brand name on something, and that, if I go to McDonald's, or excuse me, if I go to Burger King, I own stock in McDonald's. If I go to Burger King and I get poisoned by a hamburger, it may be a franchise outlet. It may not be owned by a Burger King company. It may be owned by a franchisee. But I can sue Burger King because they are the ones who whose brand name is on it. Something else that you should do when you're registering trademark rights, pick a domain name that you can register. Don't say, oh, the trademark I want, the .com is gone. So I'll just add Hawaii after it. Don't do that. Don't do that. Register, find a different name. And then don't check and then come back later. Someone will have registered in the meantime. If you find the domain name that matches your trademark and it's available on the .com, register it immediately, right then and there, because that is going to be really, really important. And if you can, register the .com, .net, .org, .us variants. The risk of a gripe site or a pornography site on one of these other alternate sites is much higher than you may expect. And the risk of just gripe sites or pornography on any domain name, if you had a client who had a legitimate domain name and they had the site up on it, someone overlooked renewing the domain name registration, somebody grabbed it while it was available and put up a pornography site. That was a Hawaii company. The risk of this happening is much higher than you may expect. You can file your federal trademark application based on your intent to use your trademark in interstate commerce. But to get your registration, you actually have to use the mark in interstate commerce. That means you got to have non-Hawaii customers. For goods, be in Waikiki or sell to the mainland or sell to a non-Hawaii business like a hotel or a Sam's Club or something like that. For services, if you're providing the services over the internet, such as your education, then that probably works. Just make sure you can prove that somebody's a non-Hawaii entity. A federal trademark application, remember, Congress only has jurisdiction over commerce between the various states and between the United States and foreign countries. Anything that purely within one state, Congress has no jurisdiction. Therefore, Congress has no jurisdiction over a trademark that's used only within one state. You can file a Hawaii trade name registration if you want, but it's not going to give you any effects outside Hawaii. Next slide, please. Should I have a professional trademark search performed? That's a very interesting question. If you're not going to be spending that much money on a trademark, and it's something where you can change your trademark if a problem shows up in 6 months, you can go ahead and file a federal trademark application after doing your own searching, and then just see what happens if the examining attorney gives you a refusal. Are you likely to change the mark in view of the search results? Let's say you've been using the mark for 20 years. You may decide not to do a professional search result. Are you willing to take the chance of a refusal or fighting with prior users or applicants or registrants? You may decide, it's not worthwhile. But on the other hand, and I did this for a client, the client says, we're buying a bunch of branches on the mainland. Is the name available? In a situation such as that, where I know the client is investing hundreds of thousands of dollars, I say you get not just one professional trademark search done, you have two. Because no trademark search is ever 100% reliable. No trademark search is 100% reliable. In my experience, the very best professional trademark searches are 75% reliable, which means about 25% of the time they're going to miss something. You can put the odds better in your favor if you have two completely independent trademark searches done by two completely independent professional search companies. If you're going to be investing tens of thousands of dollars in advertising the brand name, yes, you should have a trademark search done. If you're going to be investing a lot of time, money, and effort and sweat, yes, you should have a professional trademark search done. But if it's just something where, it's not really going to be going too far, and I've done my own searching on the internet, I couldn't find anything, and I'm willing to take the risk, then you can go without it. Professional trademark searches, the cheap ones cost $1,000 or less, slightly less, depending on how soon you need it and how many classes of goods and services there are, how many categories of goods and services there are. But a professional one can also range to $1,000 to $2,000 for just one class. I use the most cost-effective that I can. If I got to do a second one, I've got to use the second most cost-effective, which is automatically going to be more expensive. Okay, next slide, please. I'm trying to make sure that I finish in 45 minutes. What kind of a trademark should you choose? I'm going to go right to the bottom line, second to bottom line. Choose a suggested mark that indirectly describes the goods or services. Because remember what I said, a descriptive mark is not protectable unless it achieves this second meaning, because you can't take words out of the English language. So two suggested marks that I always use as examples are Oasis for a water fountain. Oasis does not directly describe a water fountain, or Igloo for coolers. Igloo, I should have said igloo instead of cooler there, but an igloo does not directly describe a cooler, but an igloo is from a cold place. So because you have to make an effort of the mind to link the brand name, Igloo, to the product, cooler, then it's an indirect description. I told the guy who represents Oasis Water Fountain Company that I use his brand name whenever I'm giving lectures on trademarks, so he found that pretty cool. You also want to think carefully in terms of your trademark, whether it translates well. There are stories going around that the Chevrolet Nova did not sell well in South America. This is not a true story, at least according to people who should be knowledgeable. It's not a true story, but it illustrates the point. It was called the Nova, and apparently it wasn't selling so well. So someone said, "Do you know what Nova means in Spanish?" No go for a car. This is true. There's a brand of drink that comes from Japan that didn't do too well in marketing, at least in certain markets, because it translates to old sweat. Now, I understand it is something that apparently is selling now in Hawaii, so I don't know whether that's because enough people in Japan or Japanese are here, they don't care about the conversation. But what I do is when a client comes to me and they say, you know, we're going to go in every other country in the world, and we really need a brand name that we can work on. I also ask them, well, make sure that you have people who are native speakers in really important countries you're dealing with, because you probably want to register the translations as well. And there are two kinds of translation. A conceptual translation translates the meaning of the word, and a phonetic translation translates the sound of the word. Katakana is a phonetic translation. And the conceptual is you use the same Japanese word for the same meaning. And you've got to think about which of those you want to use as a translation. In Japan, people usually use the katakana. If you're doing a trademark that you might need to use in China or the other Chinese-speaking jurisdictions, you should be talking to somebody who is from Singapore, Taiwan, Hong Kong, and mainland China, and seeing how that brand will work in all those markets, because people do buy things based on trademarks. That is why I say that the most valuable species of intellectual property is trademarks. Even though I am a patent attorney and I've obtained patents that have made millions of dollars for my clients, I have registered trademarks, registered copyrights, I've litigated all of those through my litigation department. Trademarks are the most valuable species because people make their purchasing decisions based on trademarks. The best example I can give you is water, dihydrogen oxide. I mean, it's a generic commodity. It's water. But you see pricing wars. People paying a lot more money for this water as opposed to that water. Clorox is chemically identical to every other bleach, yet people are willing to pay a price twice as high just because of the brand name Clorox. The difference between the high-end Lexus, its high-end Toyota Camry, and the lowest-end Lexus is $7,000 in the name. Next slide, please. How do you register your trademarks rights in Hawaii? Don't try to do it on your own. The examiners are much stricter in examining specimens now. Here, I listed the most common mistakes. You select the wrong trademarks, too descriptive. Oh, that's the other thing. The descriptiveness problems and all I'm telling you about in the US, they also apply in foreign countries. But the biggest mistakes everyone makes, they pick a descriptive name and they get a refusal for descriptiveness. They use the wrong entity as the owner. They give an identification of goods and services wrong. You get deceived by the solicitations. You file yourself, you're going to get bombarded by these fraudulent solicitations. Whenever someone contacts me, I send them an email with my booklet, and it has links to the U.S. Patent and Trademark Office website with the warnings about the fraudulent solicitations from people on trademarks, and also links to the Federal Trade Commission's warnings about these deceptive invention assistance organizations. There are many other common mistakes. The U.S. Patent and Trademark Office requires or recommends that you use an experienced trademark attorney. In my view, someone has to have handled at least several dozen federal trademark applications to registration before I can consider him or her experienced. Next slide, please. What's a trademark notice? Letter R in a circle. You guys have seen it. If you don't use it and you got a federal registration, you don't get any profits or damages. I had a client once that said, we don't like the look of it, so we're not going to use it, even though it means we can't get profits or damages. Oh, well, that's a business decision. If before you registered, use TM or SM. You want to note that you want to basically say, this is a trademark. So it's like a no trespassing sign. No real legal effect, but it has the practical effect of warning people, this is a trademark. Some foreign countries have different requirements. They may not allow you to use an R with a circle if you're not registered in that country. Next slide, please. What's the statute of limitations? The federal statute does not have a statute of limitations, unlike the copyright statute. So the federal, of course, will apply the closest analogous statute of limitations, which is probably 6 years. Next slide, please. Are your trademark rights protected in foreign countries? No. Trademarks are country by country. The trademark protection in the U.S. is worthless outside the U.S. There are possible exceptions. I was very lucky that once I had some pirate filed a trademark application for one of my clients in China for exactly the same name, but the Chinese examiner said, wait a minute, that's a name that's well known in the US, so he refused registration. Thank goodness. We didn't have to do anything on that one. So you file country by country, or the United States, 10 years ago or so, joined the Madrid Protocol, which covers 90 countries or something like that. I forgot exactly how many. But most of the major industrialized countries are members of the Madrid Protocol. A couple are not. And so The Madrid Protocol allows you to file a U.S. application or registration. That becomes the basic application or registration. And then you can file an international application to get an international registration that designates one or more of the Madrid Protocol countries. If you select only one, then you end up with an international registration that's only good in one country, and you have your U.S. registration. That's it. That's not worthwhile. If someone says, I only want trademark registrations like 3 countries, I say do it country by country. But if someone says, I need trademark rights in 3, 4, 5, 6, 7 countries, and I don't know, I might need more, then I say, well, then you may want to think about filing a U.S. application and then getting an international registration. And then with the international registration designating a bunch of countries. And then if you want to, you can add more by subsequent designation. The problem with using the Madrid Protocol is that you're putting all your eggs in one basket. If your basic U.S. application or registration is canceled or abandoned in the first 5 years, every single one of your foreign extensions of protection also is canceled or abandoned to exactly the same extent. So if you run into a problem with your U.S. application, you've also made that into a problem with your foreign registrations. Most countries are stricter than the U.S. about descriptive, misdescriptive, or geographically descriptive marks. If you file an application for a product and the product has the name Honolulu or Hawaii in it in Japan or many other countries, they will require you to limit the identification of goods or services to goods or services that are made in Hawaii or Honolulu or whatever the geographic term is named. And then, as I said, you can have possible recordation with customs in foreign countries. I think my time is up because we want to leave some time for questions. Next slide, please. It should be the last slide.
Great work, Martin. Thank you so much.
Thank you. Are there any questions?
So, let's start with the questions that were posed by our viewers. The first one is, does fair use have a percentage connected to it? For example, not more than 49% of the name, graphic, audio file, etc.
No, there's no such thing. Fair use also applies in copyright context. In the trademark context, fair use refers to a completely different thing. Fair use in the trademark context means it's a word in the English language that you can use. Fair use in the copyright context refers to what we discussed last week, which is balancing the 4 factors, and there is no percentage. The question is whether you're taking qualitatively the heart of the work in the fair use, and that session was recorded, and I don't know whether it's up on the website yet, but you can look at that, and there I did put the statutory section of the analysis for fair use.
Perfect.
Next question. Yeah.
The next question is, so what about all those companies online that say they can trademark your stuff for cheap? Is that a scam?
Yes.
Okay.
It's a scam. There was one guy called the Trademark Company, I forgot his name, but he was filing thousands of trademark applications. And it's a scam because he was having paralegals do it and he wasn't looking at it. And that's a violation of the rules of practice because only an attorney licensed to practice law can file the trademark application. Mm-hmm. If you're not an attorney, and then what LegalZoom was doing, and this is what clients have told me, what they were doing is preparing it for the client and then seeing the client put their own name so that they would not be violating that prohibition on someone doing it who's not an attorney. Do not use LegalZoom. And I know this is being recorded. I know LegalZoom may decide that they're going to sue me for libel or slander, but truth is an absolute defense. Do not use LegalZoom because the ones that I've seen by LegalZoom, the applications were done very poorly. They were not done with any consideration of the issues you may have. And some of them were so bad, I could not save the applications. So I realize there are people who are arguing that, yeah, you should be able to do it real simple and you can do it. No, you cannot. You need to have, in fact, a non-trademark attorney is almost certainly going to screw it up as well.
Got it.
So that's why you need to have someone who knows what they're doing.
So let's speak about cost for a minute. What is a range that someone should expect for, just a simple trademark application? Let's say I want to trademark the company name that I have because I'm planning on, using it on the web and so on and so forth. So if I wanted to come to a trademark attorney to trademark that, what would that run me? How many days would it take to actually get the, to process the application?
Okay. I'll give you the nitty gritty here.
Okay.
First thing is I would not be able to do it because you said you want to get trademarked the name. That's a trade name. Right. There's no such thing as federal registration for a trade name. It has to be goods or services. Everything has to be goods or services. So let's say it's goods. Let's say it's entertainment services provided over the internet. There are 45 classes of goods and services. They are set by an international treaty called the Treaty of Nice. Everyone in the world uses the same international classification, even the Business Registration Division of the Department of Commerce and Consumer Affairs, when you're doing a state of Hawaii trademark or service mark. So the filing fee is between $275 and $325 per mark per class. There are two kinds of marks. There's standard character marks where you have words only, and it covers all capitalizations, all fonts, doesn't matter what the design is. Or there's special form marks where it's restricted to the graphic appearance. I always tell people register standard characters first because we communicate with words and it doesn't matter what the capitalization is. And only if the graphic element provides enough of an independent and separate commercial value should you file the application for the graphic as a separate mark, because like the Nike swoosh, it appears separately or has a separate recognition. So you have not used it. Usually what happens, clients come to me, they haven't used the trademark yet. And so what I do is I file based on intent to use the application. File the intent to use application, naming the correct entity, because it better be a limited liability entity for the right goods and services. And that's a really big question, what goods and services to the list, because you cannot add anything to the goods and services. You cannot broaden the goods and services. Once you file the application for this recited goods and services, the application is set in stone. You can only reduce the scope of the identification of goods and services. You file the application, gets picked up by a trademark examining attorney. Nowadays, they're running about 6 months before they pick it up for initial examination.
Wow.
Trademark examining attorney, when he or she picks it up, will look at it. You're going to do two primarily things. First, they're going to see if somebody else has a federal trademark application or federal registration that blocks you. They're deaf, dumb, and blind. They only look at their own files. They do not look to see if there's any unregistered marks. They don't look to see if there's any state registered marks. They don't look to see if there's any foreign registered marks. They look only at their own files. Then they also look to see whether the mark is descriptive or misdescriptive. Those are the two primary reasons on which you'll get a refusal. If there's no problem, then you'll get what's called a notice of publication. They'll approve it, and then about 2 months later, you get a notice of publication saying, okay, you're going to be published. If you're published, anyone who objects has 30 days to say, I object. That's shorter than a lot of countries. A lot of countries give 3 months. 30 days to say, I object. If they object, what's called an opposition is filed. And right now we're settling an opposition against somebody because we filed an opposition against them because we need to make sure our client had the rights. So anyway, we filed the opposition. Someone might file an opposition. Most applications do not get a code. So let's just say nobody files an opposition. Then what happens, you get what's called a notice of allowance. Notice of allowance just says, okay, you've got a nationwide reservation for these rights. The attorney's fees for filing originally was somewhere between $500 to $1,000. It depends on how efficient you are in using my time in order to be able to do it. If you have to go back and forth and you can't really decide what the identification of goods are, or you haven't figured out what the identification is, you're burning my time and your money. But let's say you're efficient and it's $500 to $1,000. You file it. And so far, that's about all you spent. Another couple $100 before either notice of publication and also the notice of allowance. When the notice of allowance happens, you have 6 months to establish your actual usage in interstate commerce for all the items, goods, and services, and file a statement of use. When you file a statement of use, then the registration issues. Well, that's fine, except for the fact that you probably listed 10 different items, and you haven't sold all of them in interstate commerce. So you have to decide, gee, am I going to file a statement of use and abandon everything else that has not been used? Well, no, maybe I want to divide it out so I have a child application to cover the ones I have used and get the other one done. Remember, I said you only have 6 months. You can buy an extension, $125. So you pay the extension fee, but you got to prepare the extension request as well. I've got to nag you to remind you, you got to pay the extension, you got to file the extension request. If you don't, the application gets abandoned. You have 5 extensions available. Each of these extensions will cost you an amount of money because I have to prepare the extension. I have to remind you, and we got to pay the extension fee. And after 3 years from the date of notice of allowance, you have to have the statement of use filed. You can't extend it any further. Statement of use typically costs $500 to $1,000 to file. Why? I've got to know for each class and each item by item, I got to know, have you actually used this trademark in interstate commerce? And the number of items you have, I need to have a specimen showing how you're actually using the trademark in interstate commerce for one of those items. But if you have more than 4 or more items in a registration and you're filing the renewal or the Section 8 declaration due between the 5th and 6th anniversary, if you have more than 5 if you have 4 or more items listed in your registration, you're eligible for being audited.
Wow.
And the audit program, they're going to audit 2,500 of these declarations every year. And when they audit, they're going to ask you, okay, you present a specimen for one item. You've got 4 in here. We need to see specimens for 2, 3, or 4 of the other ones. And you better have those, because if you don't have them, you've got to cancel those items out, and they're charging you a huge amount, a couple $100 for canceling them. Mm-hmm. Now, all this is dependent on when you establish your actual usage. So when you ask me, how much does it cost? I'll tell you the cheapest way to do it. You've already established federal trademark. You've already established use from federal commerce, interstate commerce. Your specimens of use, that's a big problem, specimens. You're actually using the trademark in a manner that's acceptable for a specimen at the Patent and Trademark Office. You're very efficient in giving me the information. I may be able to get you the application filed for $1,000.
Got it. Got it. And then, but again, following those steps, which again would be a very regimented, a very regimented, very intentional way.
But what happens if I do it that way? If I do it as a use-based application and no opposition, instead of getting the notice of allowance, you get your registration certificate. I've got clients, many of my clients who did it that way, they paid less than $2,000.
That's great.
And that's for nationwide rights.
Which is amazing, because I've heard horror stories of, in the hundreds of thousands of dollars, but that's
I gave a speech once to an audience, and somebody up in the audience got up and said, we spent $30,000 on 2 of the best law firms in this state on getting some foreign trademark applications and foreign trademarks registered, and we got nothing. What can you do for me? I said, you didn't hire me. I can't help you on that. You've got to know what you're doing. And that's why if you hire somebody who doesn't know what they're doing, if someone says they know what they're doing, ask them how many federal trademark registrations have you prosecuted through to issuance. If it's anything less than 30, don't hire them.
That's great.
USPTO.gov. Write down that website, USPTO.gov. That's for the United States Patent and Trademark Office.gov.
Perfect.
USPTO.gov. You can look at all trademarks.
Great. I will add that in the email that will contain the slides for those who participated. So here's another question. Mahalo for this wonderful talk. I just want to confirm my understanding of what Mr. Hsia said earlier about the choice of jurisdiction for filing an infringement suit. You're a Hawaii company with a federal trademark registration. Are you restricted to filing a suit in Hawaii? But if a foreign subsidiary owns the trademark, you can file suit in any American state? ? Is the process for foreign entity registration, registering a federal trademark, more difficult than it is for a U.S. entity?
Well, let me take the second one first. That's easy. It doesn't matter whether you're a foreign entity or not in terms of registration, except for one thing. Because the large number of fraudulent Section 8 declarations of continuing use that were filed by Chinese corporations over the last couple of years, all corporations, all juristic entities, anyone who's not a natural person is required to provide a street address showing where their principal place of business is, because a foreign entity can create a U.S. entity, but you can't use a P.O. box. So that's the difference between a foreign entity filing a trademark application. With respect to where to sue, if you are a Hawaii entity and somebody is infringing on your trademark on the mainland, the first question is, are you expanding into that jurisdiction? If you're not, you can't file a lawsuit anyway, because you only can use your federal registration to push out somebody once you're about to expand into that jurisdiction. Until that time period, there's no intersection of geographic markers and therefore no infringement, so you cannot take any action. Now, that's not true with respect to things that are done over the internet, because there's no geographic separation over the internet. At that point, what you've got to do is you got to look at, okay, where can I sue these people? If the infringer is on the internet and they are a foreign entity, the federal rules of civil procedure say that the U.S. Code says that you can sue a foreign entity in any jurisdiction. But then you got to think about whether Hawaii has jurisdiction over them. And if they got Hawaii clients, Hawaii customs, we can sue them there. We usually see it from the reverse side, where some California guy says, you're a Hawaii company, but you've got California customers, so we're suing you in California. So if you're on the internet, be aware that when you're on the internet and you're shipping stuff to a jurisdiction, you may be subjecting yourself to being able to be sued in that jurisdiction. So that's why this is an interplay of 2 different concepts. One is what's called venue, which is where the court could have jurisdiction, where you have multiple courts with jurisdiction, where you pick it. and the other one is jurisdiction, and which courts have jurisdiction. One is in the, they're both in the US code now, come to think of it. The venue, but there's special venue statute for patents. That's why I said patents are different. And the US Supreme Court just changed the interpretation of that from some lower courts. And then there's the general venues provision of the US code, which is what applies to copyrights as well. Next question.
The next question is, I'm a bit confused as to why, after creation of an LLC, that I should file a trademark. Am I just trademarking the name? I thought I needed a logo as well. No.
What? An LLC is just an entity. You're just creating the name of the entity. A business, the definition of business, my definition of business is providing goods and services to others for a profit. No one has ever been able to tell me my definition is wrong. Providing goods or services for a profit to others for a profit. So the question is, you formed an LLC. Are you in business? If you are, then you're probably providing goods or services to somebody. So what the trademark is for the goods or services, the brand name. A trademark is your reputation. It is your reputation. It symbolizes your reputation. That is why the trademark is the most important asset that the company has. The likelihood of future business based on goodwill, that's your reputation. If Coca-Cola lost every single bit of its physical assets tomorrow in a big fire, every bank in the world would be willing to lend them enough money to be able to rebuild because of that trademark.
Right.
That's why trademarks are so important.
That's great. When you trade, here's another question. I think it's our last question. When you trademark and have both a tag statement and symbol, do you need two separate trademark applications?
I would usually register both of them separately. The trademark, because the trademark is going to appear at various places without the tagline, and the tagline, because the tagline may appear separately and away from the trademark. If you put them both together, then someone can infringe on your trademark and say, well, I'm not infringing on your trademark registration because I don't have the tagline, and vice versa. The less stuff you have in a registration, the broader the coverage is, but it also more likely you run into conflict with somebody else who may have an earlier registration.
Got it. Martin, it's been an amazing hour and 5 minutes. Thank you so much.
I went over, sorry.
No. This is an incredibly thick subject, rich subject. The fact you were able to pour through it in 45 minutes, help answer those questions, make your slides available, and of course, we'll make this video available on the web is amazing. So thank you so much.
All right, thank you very much for having me. I greatly appreciate the opportunity because I want to make sure the creative industries do well for Hawaii. I live here.
Thank you so much. Your commitment shined through. So we appreciated your time and your partnership in these last two presentations. And as we wrap the evening, I want to let you all know that next week we will be holding a legal clinic on the subject of options. The webinar is scheduled for Wednesday, June 16th at 1 p.m. Hawaii and will be led by Elsa Ramo. Please visit creativelab.hawaii.gov for registration information. And on behalf of Martin, the State of Hawaii DBED Creative Industries Division, mahalo and have a wonderful evening.